Good afternoon, everybody. Welcome to the training. We're going to wait just a moment as people get admitted. Hi, Kate. Hi, Gurdeep. Um, Hello again, everyone. I'm Paul Blasi. I'm with the DC Pro Bono Center. Thank you for coming to this training on tenants affirmative rights. I think we have a pretty good number of people, so I don't know, Kate, do you feel like we should begin, or do you want to wait until, I don't know, 12:05 or 04?
I think we're ready with this money. Thank you everyone for being on time.
Yeah, thank you all for being on time. And thank you, Gurdeep, for helping us out and all your incredibly important support. So, again, welcome everyone. This is the Introduction to Tenants Affirmative Rights training for the Landlord Tenant Resource Center. I'm Paul DeBlasi. I'm the Managing Attorney for Housing, and I'm shared by my colleague, Kate Room. Kate, do you want to just, people know you. Do you want to introduce yourself briefly?
Hi everyone, Kate Rue. I am the pro bono support attorney for housing at the Pro Bono Center, and you've probably seen me if you have Tuesday or Thursday shifts on LTRC.
Thank you, Kate. And so, yeah, this is a training about tenants affirmative rights. Thank you all for volunteering or considering volunteering the Landlord Tenant Resource Center. As you all likely know, Landlord Tenant Resource Center is a way um, us for us as well as a team to assist tenants and landlords that otherwise would not be able to get legal services or would have a very, very, very hard time getting any kind of legal services, and is a really important part of filling the gap for assistance to for legal assistance to people that are facing these kinds of issues in the District of Columbia. There are not enough there's not enough legal service attorneys to represent anywhere near the number of tenants that need legal representation, and volunteering with a lot of resource center is really important for assisting those tenants, and also important for small landlords that have a difficulty affording an attorney and otherwise really would have very hard time figuring out what to do in their cases and how to proceed. And here you can see that, I think you guys know how to get in touch with us, but here are our emails. So if you have any questions, certainly during the proceeding, please feel free to ask questions. You could just, I think there's an icon. You could raise your hand sort of in Zoom. And if I don't catch it or Kate doesn't catch it, I think Gurdeep is also looking to see if anyone's raising their hands. So we're happy to answer questions throughout the training. And this training is really geared, not for you all to have, you're not understandably, we're not expecting you to leave this training with a complete idea of all the affirmative rights tenants have and how to assert them in the District of Columbia. This training is building off of the other trainings that we've given about introduction to landlord tenant practice and client-centered and providing client-centered assistance to tenants and landlords. Here, we're kind of focusing on some of the other issues that come up in the context of the resource center related to tenants, I think, to help you be able to provide better legal information and assistance to those tenants. But certainly, you know, we're really just trying to give you a framework, so hopefully a somewhat better understanding of how to assist with tenants, and also when to ask questions so that when you can identify there's a potential issue that might be helpful to check in with a supervisor so that we can give them better information and potentially otherwise better address whatever kind of legal concern that they have. And here we have our sort of sections and corresponding goals. So for this training, we want to identify the tenants affirmative rights that most often apply to landlord tenant resource center callers. So again, there's lots of, as you all know, there's lots of rights that tenants have in the district, both under district law and federal law. We're not going to go really in depth on any of them, and we're not going to really touch that much on many of them. But these are some of the ones that come up most often in the context of the landlord tenant resource center. Um, Understand the forms, or a person seeking legal information from the Landlord Tenant Resource Center may have to appear in the district. Understand tenants' options to seal landlord and tenant branch cases, which is a key issue that comes up in the Resource Center for tenants. understand tenants' options to address housing code violations, which I think and many of you know is really perhaps the most key issue besides facing eviction that comes up for tenants, and understand tenants' options to challenge rent increases and other adverse decisions related to their subsidies. And just to be clear, subsidies, there's like a wide variety of subsidies that apply in the District of Columbia, both local and federal subsidies. And so really we're not anywhere going near getting into the details of all those programs. But hopefully this will just give some framework for being able to issue spot when there's maybe an issue, there's something that you want to raise with a supervisor to help provide better assistance to that tenant. And then with rent increases, particularly in the context of rent stabilization, we'll give a little bit of detail about that might help if that's an issue that emerges in some of that in an intake that you're handling. And so we're going to start, with that, with a little bit of review. If you might remember this from a previous training, but just to go over some of the authority and forums of the District of Columbia. So the authority that applies to the District of Columbia is local code. So, so local statutes, issued by DC Council. There's also municipal regulations that are issued by a variety of DC agencies. And which also include many entities that subsidize, that are involved in subsidies for tenants. And so regulations are generally very important, but they'll certainly be really important for those kinds of programs, tenants with those kinds of issues. The United States Code also applies, especially in the context of federal subsidies, or if there's an issue related to potentially to anti-discrimination law, like fair housing, although there's also pretty substantial DC law related to fair housing as well. And the Code of Federal Regulations, which again would apply in all those different kinds of contexts. And generally, also in terms of authority, where in court there's going to be the rules of the District of Columbia Court of Appeals. There's going to be Superior Court rules, which apply to all the different kind of divisions and branches of DC Superior Court. Judges, associate judges in DC Superior Court will have their own supplements to their orders, which will be important to practice in their court if you happen to be in the court of a certain judge. And there'll be the court's administrative orders, which will have an impact on handling lots of different proceedings in different kind of courts. And also, if I remember correctly, is actually the main sort of procedural authority related to housing conditions. So it's an administrative order. So those might not be obvious, but those could be very, very important in handling your cases. And we're going to talk a little bit about when we're talking about rent stabilization, and we're talking about subsidy programs, which is also going to be administrative entities that we're going to be that'll often be here. They'll be the forums for handling these issues, but in those contexts, usually it's going to be a set, like they might have their own materials that they produce that have the rules and regulations for handling those cases, but those will generally be also creatures of statute and or the municipal regulations. So for example, the Office of Administrative Hearings, while they issue their own rules, those rules are actually DC municipal regulations that are available there as well. And so moving on to the forums, which we've already started talking about, where tenants may assert affirmative rights. Here, again, this might be very familiar. These are the courts, parts of DC Superior Court, where disputes might arise. Landlord tenants may bring legal disputes to several different branches, encounters the DC Civil Division of DC Superior Court. The Court of Appeals here takes appeals from all these courts. So the Court of Appeals is over all these courts. And as you all probably familiar with from the other training, landlord-tenant branch is where eviction cases are filed. Not necessarily all landlord-tenant disputes are heard here. Just it's really about cases where one party seeking to remove another party from possession of a home or a commercial property that are heard here. Small Claims and Conciliation Branch is the branch for any dispute that relates to getting damages of up to $10,000 that can be brought there. It can't be more than $10,000, and that court only provides monetary damages. It doesn't provide any kind of injunctive relief. While on a tenant branch, you can't go in unless you, as a plaintiff, are seeking possession of a property. You might get other remedies, but just for possession. And civil actions branch, which is sort of the court of general civil jurisdiction in District of Columbia, can hear matters that are either for more than $10,000 and or matters for other kinds of injunctive relief. And so, perhaps, and the House Commission's calendar is actually a calendar of the civil action branch we're going to talk about in more depth later on. This is also where the associate judge calendars are. So as you might remember from the other training, if a case is certified in the civil actions branch to have a trial before a jury, then that case is also going to be certified to an associate judge on their calendar. And that's when the supplemental order of that particular judge might be really important in kind of figuring out how you want to handle that case. And I've already gone over a lot of, I've already kind of touched on a lot of this, but just to review, for landlord tenant branch, plaintiffs may seek possession of real property from tenants, foreclosed homeowners, and other persons alleged to not have a right to possession. The court enters a judgment for possession that allows the eviction to proceed. The plaintiff prevails. The tenant who's been sued for non-payment of rent may counterclaim against their landlord for money judgment and injunctive relief. And these, by the way, are very similar to what these other kind of remedies we're going to talk about for addressing housing code violations, because the counterclaims for either money judgment or injunctive relief are basically counterclaims for failure to address housing code violations under the implied warrant of habitability or void lease. And so so while it's a different forum, like the kind of mechanism we're talking about later to seek either damages or injunctive relief for failure to address housing code violations by a landlord are, it's basically the same claim. It's just different form, which has different remedies available. And the court, in the tenant branch may enter a money judgment in non-payment rent cases if the tenant was personally served and filed a counterclaim for money judgment. And as we referenced earlier, like it's about judgment for possession, for getting possession of a home. So the landlord, if they prevail, can get possession of the home. If the tenant prevails, or if the case is otherwise resolved, the tenant keeps possession of the home. And the other common forms for tenants in DC Superior Court are the housing actions calendar of the civil actions branch, which we saw earlier, where a tenant may file a complaint seeking to have the landlord address housing code violations. The court may award injunctive relief and sanctions, but not monetary damages. We'll get into more detail about that later. We'll talk about that more later. And the small claims and conciliation branch, which, as I said before, is where a tenant or landlord may seek monetary damages equal to or less than $10,000, and that court does not award injunctive relief. And Kate will touch upon that very briefly, because that is a place that potentially a tenant can, if they're really interested in getting money back and not other kind of relief, that's a place that they can go if they're having a problem with their landlord repairing, addressing housing code violations in their home. Now, to give an example of another kind of forum where tenants can assert their rights, and we're going to spend a little bit more time with rent stabilization and tenant petitions and with the variety of other kind of administrative actions that are potentially available to tenants, but that those are heard in the Office of, like challenges to rent increases and other rights related to rent stabilization are heard in the Office of Administrative Hearings, which is an administrative body that has administrative law judges that hears a wide variety of issues. Like there's a very large variety of issues that are heard in the Office of Administrative Hearings, but one of them are issues related to rent stabilization. This is also a forum actually where landlords can also seek relief if they're seeking to take increases that are higher than what's regularly allowed under the law. But if a tenant is seeking kind of remedy related to their rights and under rent stabilization, they can seek relief here. They do that by filing a tenant petition that is filed with the Rental Accommodations Division, which is the agency that runs rent stabilization, and is heard in the Office of Administrative Hearings before an administrative law judge. Sorry for the typo. No. And so it's filed here in the Rental Accommodations Division, and then it goes after some review. The tenant might be emailed back that they need to attach something else to their complaint, but then it's heard in the Office of Administrative Hearings, and then from there, petitions are appealed to the Rental Housing Commission, and then from there, they're appealed to the DC Court of Appeals. So there's a pretty long appeal process if there's a dispute, if someone wants to appeal whatever happens at the end of this process. Other forums for tenants in the district, we're not going to talk very much about for housing law, but the Office of Human Rights, the DC Commission on Human Rights, are forums that relate to violations of the DC Human Rights Act, which include many protections related to housing for tenants. So tenants may seek a remedy for violations of the DC Human Rights Act. for the Office of Human Rights, basically. And this is the Office of Human Rights is more of an investigative body. So a tenant files a complaint there relating to some kind of form of housing discrimination, might be failure to provide a reasonable accommodation to a tenant who has a disability of some kind, might be some other form of discrimination related to a protected category, such as a source of income or race or sex or sexual orientation, or there's a wide familial status. And then there's basically the Office of Human Rights works to investigate the discrimination complaint and to try and mediate the problem. And if it doesn't resolve through mediation, and if the Office of Human Rights does find probable cause for that discrimination did occur, then if the tenant chooses, the case isn't resolved otherwise, they can pursue that further through the to the Commission on Human Rights, which is basically like an administrative adjudicative body that can hear decisions and make decisions related and grant relief related to discrimination complaints. And by the way, like if there is fair housing problems, like the tenant could also potentially file in DC Superior Court or in federal court, depending on what their claims are. But this is a relatively more pro se friendly forum than those other forums. And then, as a big catch-all, which you'll hear about which you'll get a few of these in this presentation, there's a lot of other forums, because depending on, like, with all these different kind of programs that potentially impact tenants, there's often a forum and a process for them to challenge that. That might be the Office of Administrative Hearings. It might be a particular other kind of forum and procedure that's created by the administrative that's related to a subsidy. So, yeah, so basically there's a wide variety of paths to challenge adverse administrative decisions. And if this issue arises, you should talk to your supervisor about it, because not to say they won't be confused, but certainly, that'd probably be a good time to check in to see what within our capacity, the limited capacity, what we can do at the research center, that, we want to take that into account in terms of giving them information in light of whatever that issue might be. And now I'm going to hand this off to Kate to talk about sealing landlord and tenant cases, which is something that happens in the landlord tenant.
All right, so for sealing cases, for the most part, we'll probably be referring any sealing callers. We do have a pretty great advocacy and justice clinic, and we take sealing tenant referrals. So we'll probably be referring those if you are working in LTRC, just a heads up. But we do want to go over the basics of sealing, especially because not everyone will want a referral. And Paul, I think you have, there we go. Thank you. So there is automatic sealing in a couple of instances under DC laws. First, if the landlord doesn't get a judgment, that can happen a couple of different ways. But if the landlord doesn't get a judgment and the case is closed, then the case automatically seals in 30 days. So it's a pretty quick sealing process if there's no judgment. If there is a judgment, it will still automatically seal. It'll just take about 3 years. So it takes a little bit longer if there is a judgment. But we do now have automatic sealing, which is pretty great. And is a lot of tenants, I think, feel a lot calmer after hearing that there's automatic sealing. And they don't have to worry so much about these records being out there and potentially impacting their ability to rent in the future. It can really be difficult to find a new apartment if you have these on your record. So this is good to know just overall. But outside of the automatic sealing, there are also opportunities to move to seal the record. So these are all under DC code, if you did want to go look it up, but these are the specific reasons why tenants can move to seal their record. So if their landlord sued for under $600, as some of you may know, in DC, landlords can only sue in landlord-tenant branch for non-payment of rent if their tenant owes $600 or more. So if their landlord sued for under $600, the tenant can move to get the record sealed. If the tenant lived in subsidized housing, that's a pretty big catch-all. A lot of our callers will probably fall into that. And that's another reason why they can get their record sealed. If the landlord brought the case in retaliation against the tenant. So in DC, retaliation, it's a rebuttable presumption, but if the tenant exercises one of their rights, most commonly we see this with the tenant trying to get repairs in their home. And if the landlord takes an action that's adverse to the tenant after the tenant invokes that right, that might be retaliation. So if the landlord does bring the case in retaliation against the tenant, if the landlord brought the case because they were mad that the tenant had asked for repairs or maybe even started a tenants association, that's another reason that they could move to seal. If the landlord failed to timely correct housing code violations, timely is definitely the operative word there, but for the most part, if the landlord failed to address the housing code violations after multiple requests by the tenant, that will apply. There are also protections related to domestic violence. So if, for example, there was, say, a lease violation and the tenant had the lease violation as a result of domestic violence. So let's say it's an unauthorized occupant, but the unauthorized occupant is the tenant's abuser. They literally couldn't get away from this person. They wanted to, but they couldn't. That's a type of situation where this reason for sealing might come up. There are other ways that you might envision that, many other unfortunate domestic violence situations, but that's one that we see, I think, most commonly. Um, Another reason is if the settlement agreement did not give the landlord possession. Tenants can move to seal if that happens. And then finally, we have a really great broad catch-all, which is any other good cause. And that really means any other good cause that you might have. We'll have to talk with tenants about the specifics, but good cause can mean a wide variety of things in these cases. And next, we'll talk about addressing housing code violations, which is, I think, a fun and frustrating topic. So, as Paul alluded to earlier, so we'll dive into it. So there are a lot of options to address violations. Each of the options has varying success rates, is what I'll say. First up, and this is going to be the first step no matter what type of case you've got, a tenant can always request the repairs in writing. I like to emphasize in writing because under certain laws, like the mold law, you actually do have to make the request for the repair in writing. So starting off with a written request for repairs, make sure that the tenant is meeting other obligations under other laws. It gives them evidence of the fact that they did make these requests. They can use that later on in an eviction case. They can use that throughout a housing conditions case. It really sets them up for the future. The second option, and I really like this one because again, it puts things in writing, is contacting the Department of Buildings, which used to be called DCRA, and requesting an inspection. So DOB will come out and will inspect the home. That's the link that we can send out. It is a pretty easy process. And they do come out usually within a couple of days, even for non-emergencies. And the tenant will get a detailed report of everything that's gone wrong in their home. They usually include pictures. It's usually a full color copy. It's a pretty good report. And again, they can use that in the future if they want to bring a housing conditions calendar case, if they have an eviction case, even small claims. All of that can come up. The next one, a tenant can withhold rent until the repairs are made. This one should come with caution and with explanation of what withholding rent could potentially mean. So if you withhold rent, even if you have all of these repairs and your home is falling apart, your landlord can still file a non-payment of rent case against you. So that's a pretty big risk, and we always want to make sure that we're telling callers about that risk when we talk about withholding rent. And if you are going to withhold rent, we'll always put this in the notes, but we try to make sure that tenants ask it or say they're going to do it in writing. You're seeing a trend here. Everything should be in writing, but putting it in writing helps them in the future, whether it be a housing conditions case or an evictions case or a small claims case. They can also then file in one of two different branches. So if they want injunctive relief, which means they're just looking for repairs, they can file a complaint on the housing conditions calendar. If they want monetary relief, but not injunctive relief, so they just want the money back, but they don't want to force repairs, then they can go to small claims branch. If they wanted to do both, they would have to do a full civil case. We really don't talk about that much, but if you heard about it, if you hear someone wanting to do both, you can also check in with your supervisor. We can at least provide some links to Superior Court Civil Actions Branch, get them started that way. So starting a housing conditions calendar case, the landlord or their agents have to know about the housing code violations before you file. So again, we talked about calling DOB or getting a written request over to the landlord. That makes sure that the notice requirements, the prerequisites for an HCC case, are met. There's also a form complaint. It's very easy. It's just a checkbox. That's all that they have to fill out. And then there's a summons sheet that comes along with it as well. Again, it's very easy. You pretty much only fill out the case caption and the tenant's name down at the bottom. And the complaint and other documents are not going to be filed in landlord tenant branch. So if you've ever volunteered with us in person, our resource center is at the landlord tenant branch, which is Court Building B. But housing conditions complaints are filed over at the Moultrie Courthouse. So that's at 500 Indiana Ave, and it's on the 5th floor, room 5000. Service of the complaint and summons. Paul mentioned earlier the housing conditions calendar being governed by an administrative order, and service is where you see this really come into play. So generally speaking, service does fall under Rule 4. However, in HCC, there are much shorter and much more lenient timelines regarding service. And those are all under the administrative orders. You can also find them, believe it or not, in the case management plan for HCC. So let's get into this a little bit. Tenants have to serve the landlord by having someone other than themselves who is over 18 years old. They can personally serve, they can serve by mail, a couple different options, but it has to be someone who is over 18 years old. They can serve a person of suitable age and discretion at the landlord's residence. They can, if they're going to, say, the property management office, if there's someone there that can accept it on behalf of the landlord, that's okay as well. Or the landlord might also have a registered agent, and they can serve the registered agent as well. Tenants can also mail a copy of the complaint and summons. If they're going to mail the copy, it has to be by registered or certified mail. That can get a little bit confusing. Sometimes people will just pop it in the mailbox and say, okay, I sent it. It has to come with, they call them the green cards or the return slip. That's how the court makes sure that it actually made its way over to the party that it was intended to reach. And if they do that, they should also have 2 copies of the notice of acknowledgement form, a prepaid envelope addressed to the sender. There's a bit that goes into that. There is also an instruction sheet available on Superior Court's website. So if a tenant is ever like, this is so much to remember, and it is a lot to remember, the court actually does have an instruction sheet, and we can always provide that. It has everything summarized for them and all of these specifics. So they can also serve them if it's a corporation or an association, pretty much the same deal. You can still do by mailing, you can still do in person. Usually, if it's a corporation, they will have a registered agent and they'll probably have a business address that it can be sent to. Just a couple more specifics. And after a diligent effort has been made, at least 2 copies of the complaint to the superintendent of the corporations. That's another option. I have had that happen in a case before where we had to serve the superintendent of corporations because the corporation was just not responding. It is a little bit of a more difficult process. It doesn't come up much for us in LTRC, but if it does, you can absolutely check in with the supervisor to see more specifics and get more information. Let's see what else we have here. Yeah, and DC can be served by serving the mayor and the corporate council. If it's a DCHA property, it'll be a little bit different. So if you happen to have a caller who's at a DCHA property, your supervisor will probably tell you the specifics about serving DCHA. They moved their headquarters, and there's been some difficulties getting service to them at their new headquarters, but there's also an email address at which DCHA specifically accepts service. So that can oftentimes be just an easier way to do it. So this is the proceedings up to the initial hearing, and I'll talk a little bit about the timing of this all. So after filing, the tenant will get back the complaint and summons. They have to serve the complaint and summons within 8 days of the initial hearing, and that'll be 8 calendar days. So it's a little different from landlord-tenant branch, where it has to be 30 days excluding Sundays and federal holidays. This one is just 8 calendar days. And after they complete service, they have to file the affidavit of service, which says, this person went and swears that they served this other person in basic terms. That should be filed at least 3 calendar days before the initial hearing. So, like I said, it's a much shorter, it's much more lenient. You have a lot more time to get this done. And that usually benefits tenants because service is tough. Service is really tough to do pro se. So part of the reason why it's a lot longer of a time to get service done, and you don't have to get your affidavit in so early, is because there are a lot of pro se filings in this branch. So that all has to happen before the initial hearing. But if that all happens, then the initial hearing will go off without a hitch. At the initial hearing, the judge will pretty much just be setting up the inspection with the court's DOB inspector. You can see that as the next step there. And then we'll probably set another status hearing. The initial hearings are very basic. There is not much to worry about at all. If there are issues with service, the judge will go over those issues at the initial hearing. So they'll address any concerns. Most of the time, if it's a pro se tenant and there are issues with service, the judge will allow for motions to extend the deadline to serve. And I've actually not seen many judges making pro se tenants say those words. They'll usually pick up on there being some issues with service, and they'll just grant it sua sponte a lot of times, which is great. So after the initial hearings, the DOB inspector will go out to the tenant's home. And really similarly to if you got just a DOB inspection outside of court, they'll write up this nice and long report with everything that they've noted. This one doesn't come with pictures and it's not in color, so it's a little bit less exciting, but it does include everything. Both parties are allowed to attend that inspection. So both tenant and landlord can have someone there. I'll say that the landlords almost never send an agent, almost never send a representative. So it'll most likely be the tenant and the court's inspector going through the home. And the tenants are able to point out things to the inspector. They don't have to hang back and only let the inspector see what they see. They can be involved in the process, and it can be an interactive process. After that inspection happens, all parties and the judge will get a copy of the inspection report. And then the judge will pretty much use that inspection report as a checklist. And I've often seen to it referred to as a quasi order. So at least recently, and because there's not much case law in HCC, I can't tell you that this is law, but at least recently, most of the judges presiding over HCC cases view the inspection report as like an order, or with the same power as an order. They expect that the parties will follow the inspection report as if it was an order. That can come in handy. Sometimes you might be able to get a motion for contempt if they are not following the order. But there are also tenant violations that pop up. Just something to keep in mind. After the inspection, it's pretty much just status hearings from there on out to make sure that the landlord is complying with the inspection report. Throughout the status hearings, tenants will have the opportunity to ask for sanctions if repairs aren't moving so quickly. So you probably saw earlier that this is only a court for injunctive relief. Let's talk a little bit about why they get sanctions. The court views sanctions as not damages. So if you see rent abatement, that's not damages for the purposes of HCC. It's only considered a sanction. And sanctions are specifically allowed in HCC. So tenants can request rent abatements, they can request sanctions, but they can't get damages. Just an important distinction there. Let's see here. And one other thing, I can just add this in here, Paul, if you want. So TROs are something that will come up sometimes in the housing conditions process. So if you have a tenant who's going through an emergency situation, a flood, a fire, carbon monoxide leak, mold, no heat in the winter, no AC in the summer, something like that. Tenants will usually have the opportunity to file a motion for temporary restraining order. A lot of people hear temporary restraining order and think, well, what are you restraining anyone from? So the TRO can ask for a lot of different things. It doesn't just have to be someone stopping a behavior, it can also be asking them to start something, such as repairs or getting the tenant into a habitable apartment or stay in a hotel for a little bit. Those are all things that tenants can ask for as part of a motion for a temporary restraining order. If that's the case, we do have a little write-up on taking them through the specifics of the law. Generally speaking, there has to be a violation of the housing code, has to be caused, by the landlord's neglect to address it. And there has to be an immediate threat to the tenant's safety, well-being, health, anything along those lines. It's immediate and irreparable. Those are the two words that you should be looking for. And there are a couple of other factors, such as public interest and whether or not it would prejudice the landlord to have this type of motion go forward. For the most part, the judges who hear those cases are not going to require a pro se tenant to be as up to date on the specifics of that law. But for the most part, also public will always favor getting these types of emergency situations repaired. Fires, no heat, that's all in the public interest. It is something we can go over with the tenant quickly. Sometimes it can be a nice little addition to the argument, but for the most part, the judges will not be looking for the tenants to list off all four of the law and get them exactly right, especially if they're pro se.
Thank you, Kate. That was fantastic. I'm now going to talk a little bit about rent increases and adverse decisions related to subsidies. And some of you might be thinking, well, what's the context? Since really the cases that you all are assisting tenants with generally revolve around housing code violations or their eviction cases.
It's for housing. It's for the landlord tenant stuff.
Excuse me?
No, until she curious and I thought it was tomorrow.
I'm sorry, I can't quite hear. Does someone have a question?
Rebecca?
Was it? That's great.
If there's Rebecca Beal, you're unmuted. I don't know if we can't hear you very well if you're asking a question.
Yeah.
I don't think there's a question. All right.
Okay.
Okay. So generally the purpose of talking about these kind of affirmative rights related to rent stabilization or related to to some degree or subsidies will be in the context of speaking to someone who's facing eviction in some kind in landlord tenant branch, and then if their unit is rent stabilized, or if they're participating or potentially participating in some kind of subsidy program, or if there's some kind of other adverse decision that has impacted their access to safe and affordable housing, such as potentially something related to emergency rental assistance, then there might be some kind of administrative procedures that relate to being able to that are relevant to the non-payment or other kind of eviction case that they're in. And so, again, to reiterate, the goal here is not for you to leave with a complete understanding of how to proceed with all these different issues, but really to help you kind of issue spot if the supervisor hasn't already issue spotted, so that if this is an issue that arises and if it's within the scope of what we can do as giving legal information, we can try to give information to the tenant that helps with these different kind of these different problems. And so we're going to begin, and we're going to talk more, in part because if you get into subsidies, it would take the rest of the week. But we'll be focusing on rent stabilization. And so in the district, rent stabilization applies to residences in the district built before 1975. And this is under the code. Residences that are not subsidized by the local or federal government, those homes are exempt from rent stabilization, and their rents are usually set under whatever kind of subsidy program applies to that unit. Residences that are not owned by an individual, but who owns 4 or less units. And I'm sorry about the negative there, but basically, so units are exempt from rent stabilization if an individual, a natural person, not a business, owns them and they own 4 or less units. They also need to apply for that exemption from rent stabilization, technically, but anyway, but that's sort of what's one of the criteria to be exempt from rent stabilization in District of Columbia. And there are other limited exceptions of rent stabilization, including, if this place is a dormitory, or other kind of, these are often exceptions from just being rental housing in general. But this means that for many residents in the District of Columbia, they are subject to rent stabilization. And that means that there's a variety of protections that apply. Most importantly, protections against rent increases, but there are other protections that apply. And so for rent stabilized units, rent increases for rent stabilized units, a landlord may only increase the rent if they satisfy the following criteria. The landlord is properly licensed and registered with the Rental Accommodations Division, and that's a entity of the Department of Housing and Community Development that handles rent stabilization. So they need to be registered with them. And some of you all might remember that if a landlord is filing an eviction lawsuit against a tenant now, they need to include their registration or exemption from rent stabilization with their complaint when they file. The unit and common areas must also substantially comply with the housing code. So if there are substantial housing code violations, either in the residence or in the common areas around the residence, then the landlord is not allowed to increase the rent if the unit is rent stabilized. The rent was last raised at least 12 months ago. So there needs to be at least a year between rent increases. For them to take effect. It can be multiple rent increases during a year. And for tenants A who are 62 years or older, or tenants with disability, the increase is not more than the consumer price index set by the district. So in the municipal regulations, each year, the district sets a certain consumer price index increase that's allowable for rent increases. And if the tenant is 62 and older or has a disability, then they can't be more than that. But to get this exemption, the tenant must register with the Rental Accommodations Division. And some of you already might have had the experience of directing a tenant who's interested in registering to the form, giving them the form so that they can register for that exemption. For all other tenants who are in rent stabilized units but do not have that exemption, then the rent increase could be no more than the consumer price index plus 2%. And the consumer price index varies a lot, because again, it's set to, so as some of you might have expected, it was higher when we had pretty high inflation. It's lower recently. A tenant may challenge an unlawful rent increase by filing a tenant petition with the Rental Accommodations Division that is heard by the Office of Administrative Hearings. We talked about that a little bit earlier when we were looking at forums. The petition can also seek overpaid rent for reduction of services and facilities and a fee for retaliation. So just to unpack that a little bit. This tenant petition is basically a way that if a tenant was facing had an unlawful rent increase, or they're saying an unlawful rent increase in a rent stabilized unit, a way for them to challenge the rent increase is to file a tenant petition, which is sort of a checkbox form that they can use. They file that with the Rental Accommodations Division. And that's sent to the Office of Administrative Hearings. If they're saying that the landlord failed to increase the rent lawfully for any of the reasons that we just described, and that would be one that could be that's basically a claim in that petition. This reduction of services and facilities in practice is very similar to the implied warranty of habitability. The remedy is basically getting some percentage of rent back at the end of the case because of the landlord failed to address a housing code violation, and so therefore reduced the value of the home. It also could apply in context where there isn't a housing code violation, like for, let's say, if the landlord did something to not allow a tenant to use their balcony or some part of their apartment or some part of the common areas. That could also be a reduction or elimination of services and facilities. And as far as retaliation, it can be a cause. This is a little bit, I think, confusing for tenants and perhaps everyone. It is another claim that can be brought in a tenant petition, saying, earlier Kate was talking about retaliation as a right that tenant has to assert if they're saying that they asserted a right and the landlord somehow retaliated or took an adverse action in response to asserting a right, such as complaining about housing code violations or some other issue. But here, the remedy is really just a fee that's paid to the city. So for many tenants, it's actually not that helpful to them to prevail on that. If a tenant's not in a rent stabilized unit, just talk about that briefly, then if a tenant is outside of their lease term, and if there isn't any kind of any other kind of subsidy program or other aspect that might impact what the rent should be, then the landlord can increase the rent with 30-day written notice, like to whatever the market will bear. Arguably, if they increase it to an incredibly high amount, so that it seems like it's just an attempt to evict the tenant, or otherwise, or is potentially the tenant could say it's retaliatory or discriminatory, or they might have arguments to get out from under it. But if a tenant isn't in a rent stabilized unit and they don't participate in some kind of subsidy program and they're not under a lease term, which dictates what the rent is, then a landlord can generally increase the rent however much the market might bear, which might be fairly high for that tenant given the circumstances. And just to talk a little bit more about the procedure, once a tenant petition is filed and sent to the Office of Administrative Hearings, there's a procedure that's very similar to many of the branches in DC Superior Court, where there's sort of an initial hearing where the parties kind of discuss how they want to schedule the case, and will likely set a mediation, potentially agree to discovery of some kind. There's limited opportunities for discovery in the Office of Administrative Hearings. There's also a mechanism to subpoena documents from parties that might be relevant to the case. And then if a mediation fails, generally there'll be another kind of hearing. It's almost like a pretrial conference to determine how long the evidentiary hearing, which is basically a trial, will take place, and who will be the witnesses and other matters related to conducting that hearing. And then that hearing will take place, and the administrative law judge will make some kind of decision about the merits and make an award to either the tenant or deny their claims. There's any counterclaims that a landlord could bring if a tenant files a tenant petition. And this sort of mirrors in a very broad way, right? Because it's just like, because it varies from program to program or issue to issue, like what might be like the kind of issues that might arise in an administrative proceeding that's related to some other kind of right the tenant might have, including subsidies. And so we're going to go much more generally here, although I'm happy to talk about more specific programs if people have questions about it. But if a tenant might also have an issue related to subsidies, because if someone was in a subsidy program and it was terminated, that can come up in an non-payment rent case where now they're saying they don't owe all this rent because really the subsidy should have been paying the rent, or they never should have been terminated from the program. They also, a tenant might be challenging, there might be an issue related to the subsidy that impacts an non-payment rent case because the tenant is saying that their rent is not calculated correctly. For many subsidy programs, the rent that a tenant is paying is based on their income. And so there might be a dispute about whether or not the income is properly calculated. Maybe the tenant lost income and reported that, but the subsidizing entity, the housing authority or the building or whatever the case might be, did not take that into account, not properly recalculate their rent, which unfortunately happens fairly frequently. Then that would also potentially be a reason there would be a dispute about that would arise in a non-payment rent case. So in many of these instances, depending on the subsidy program, there's got to be some kind of right to challenge adverse decisions. And I just gave some examples, but when I talk about an adverse decisions, they might include the proposed termination of a subsidy, removing someone from the subsidy program, a change in the rent that tenant disagrees with, a barring notice, and that's basically notice saying that a member of a tenant's family or household cannot come to the property. They also might try to bar the tenant from coming to their own home, but I think that's pretty illegal. Not to mean that won't happen. a refusal to change the composition of the participant's household. So say the tenant wants to add someone, often like if someone's in a subsidized housing program, there's, as you might have already gathered, a lot of regulations and hoops and barriers for their participation in that program that they need to comply with. So if they want to add someone to the household or remove someone from the household, generally that needs to go through whatever the subsidizing entity. And so there might be disagreement about that or issue with that that the tenant wants to challenge. And lots of other issues, right? These are just some examples. And then depending on the program, there's going to be the specific procedure and forum to challenge an adverse decision will depend on the subsidy program in question. But there's nearly always an all too short administrative deadline for the participants to challenge the decision. So I guess the key point here is first that this is going to vary a lot by program, as I'm saying over and over again. And also, but almost always, if there is an administrative way to challenge an adverse decision, then there's going to be a deadline. That's going to be, often a matter of like weeks or days, not months or years, for them to challenge that. And so if you think that some issue like this is arising and this hasn't already been spotted by the supervisor, you should raise it with the supervisor, and it might be important for them to speak to someone where they can actually, to share that, to get more information about that, or to be referred to someone that can look at that information and provide further assistance so that they won't risk missing one of those deadlines, which might be important. But besides that, often not always, the participant may be able to challenge these adverse decisions through asserting an offense in an eviction case. So it's not uncommon that, for example, if the subsidy is being terminated or there's some kind of, for whatever reason, that then there'll be a non-payment of rent case that follows based on the tenant failing to be, not being unable to pay the amount of rent they're being charged now after the subsidy being terminated. And often tenants can assert defenses in that case, and that's something else you might be encountering in the context of giving information or some assistance in the context of an eviction case. And as I've been saying throughout, if these things like, if any of these issues arise, really, if any of the ones that we've been talking about during this presentation, if they arise, you should check it with your supervisor. If they haven't already highlighted them with you, and obviously if you have questions, you should check it with your supervisor and ask them questions. But definitely, if this wasn't something, if an issue arises that your supervisor didn't already address, that you should ask them about it so we can give you more guidance, because these issues can be quite complex and quite specific to whatever program or particular problem that tenant may have. And so I'm going to, I don't know, is there anything you want to add before we start taking questions, Kate? Okay, all right, well, I'll stop sharing. And so, yeah, thank you all for joining. I wanted to, really appreciate all of your work of you and your colleagues, the Resource Center, to help tenants and landlords in the district. It really meets it's really important for meeting the gap in services in the district. Do people have any questions about any of the different subjects that Kate and I touched on during this presentation, or other issues that maybe have come up in your own experience as a volunteer that you'd like to chat about? All right. Well, I think then, well, we're gonna, so we, as you all, I think are probably aware, we're recording this now. So we'll be sharing the recording with everyone after the presentation. We also will be sharing the slides as well. And so, I will stay on for a little bit in case anyone still has questions and that they'd like to ask, maybe in a slightly smaller group. But then you have our email, so please feel free to reach out with any questions or issues we have. Again, we really appreciate you volunteering with us for the Resource Center. Also, soon there'll be another email recruiting for the in-person Resource Center. We, as many of you I think know, we're open again at the landlord tenant branch, our office there, providing assistance to tenants and landlords in person. And so again, if you're interested in that, please feel free to sign up or reach out to me with questions about it. I'm happy to answer them. And I hope that everyone has a great rest of your day. Thank you, Kate, and thank you, Gurdeep, for all your help with this. Thanks to all of you. for coming.
Thank you.
Thank you.